We're here on our miscellaneous criminal day. We have this. Oh, yes. Mr. Rare.
Good morning, Your Honor. The first felony case I have this morning is Mr. David Canham. He's present and approaching. Your Honor, we have an agreement with the state for his two VOP cases, 20 CF 1178, 21 CF 662. There will be an admission of the VOPs, maintain, withhold, reinstate, probation, complete original requirements, and there will be a $100 VOP fee assessed. Could I approach?
You may. State agreement.
Yes, Your Honor, that's the state's agreement. And basically, Your Honor, just so you know, after speaking with Mr. Rare and looking at the Escambia County new law violation, most of the stuff that's in violation status, it looked like had been taken care of, and the offer on the Escambia County new misdemeanor required no probation. So that's the reason for the reinstatement.
Sir, would you raise your right hand? You swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God. So you heard your attorney state the terms of your plea agreement, and I see that those same terms are contained in the written plea agreement. Have you read this plea agreement closely?
Yes.
And you understand that by entering this plea agreement, you're waiving the right to go to a hearing. You've got some legal rights you're basically waiving. Gone over all that with your attorney?
Yes.
Believe this is in your best interest?
I do.
If you have any further questions about this plea agreement that you need to talk about with your attorney before we enter it?
No.
Very good. Based upon that testimony, the court will accept your testimony here today. There'll be an admission of the violation of probation. We'll maintain the withhold, reinstate probation, and complete all the original requirements, and there'll be a $100 additional VOP fee. Any questions?
No. No, Your Honor.
Is that the case, Mr. Earl?
It is. That's all I've got.
Mr. Garrett?
He's speaking with us anyway.
Okay. Mr. Durrell?
Yes, Your Honor. May it please the court, Dustin Durrell, on behalf of Ms. Kenesha Austin. Ms. Austin is present, Your Honor. Your Honor, we have an agreement with the state. However, we're asking to enter the plea on the court's next available day in August, if we may, Your Honor. But we do have an understanding for resolution of this case.
Okay. You want to just come back on another miscellaneous day in August?
Yes, Your Honor. What would that day be?
17th? Where numbers at now?
You're now at 19 in the morning, but just a few days later, on the 22nd of August, you only have 3 days.
Let's do the 22nd, August 22nd at 9 a.m.
August 22nd at 9. Yes, Your Honor. And that will be for entry of the plea.
Very good, thank you.
Thank you, Your Honor.
Mr. Tony.
Good morning, Your Honor. Your Honor, this is Calvin. We set this for, I'm sorry, Your Honor, Jeff Tony in case 21 CF 00970, State versus Brian Colin. You know, we had set this for plea and sentences today, but I hadn't had an opportunity to talk to Mrs. Basso about it. We had an evaluation, and that was from Holden, that I wanted her to review it, and then also I wanted my client to have an opportunity to review it. I dropped it off to her office last week, and consequently I found that she wouldn't be available today. Yeah, can we can push it to the next miscellaneous day, Your Honor.
Okay. Let's do it on August 22nd. Do you anticipate it being a plea on that?
Yes, sir. In here, it's going to be a plea, but the issue now is the sentencing and the gravity of said sentencing, to the extent that we want to, we're probably going to be bringing in an expert to attest to the court.
Whatever the agreement is, that's between you and the state. The court will only get involved to the degree that.
So I have,
Okay.
so we got
We'll continue until August 22nd, 9 a.m.
that's all I have, Judge. May I be excused?
Now, do you anticipate the plea, that the sentencing will take place? I'm a little bit unclear. Are you anticipating a plea to the bench where there'd be a evidentiary hearing, the testimony, is what you're saying?
Yes, sir. Here's what I anticipate. I think about what we're going to do is we probably at that point, we're going to just enter into a plea. Then reserve sentencing for a
Come back at a time where you can both
Yes, sir. Yes, sir.
schedule an
Yes, sir.
evidentiary, whatever testimony.
Correct.
Fine. So it'll be in the morning on 8/22, 9 a.m. So it's going to be an evidentiary. We needed to have it in the afternoon. Okay?
All right.
Any
Thank you,
further?
sir.
Thank you. Okay. Let's go ahead and do a few of the people that are here without attorneys. We'll begin with Alicia Irby. Would the state announce this? Come up to the podium. It's all right. Who's handling this?
Yes, Your Honor, this is Miss Alicia Irby, case number 22 CF 2875. She's charged with petty theft under $300 felony. If she'd like to resolve this today,
Isn't this a VOP?
Oh, I apologize. Yes, Your Honor, it is a VOP on that underlying charge. If she'd like to resolve this today, it offers 11 months and 29 days of Okaloosa County Jail.
Okay.
With credit time served.
Okay, generally, we're not going to do any pleas without talking to an attorney, unless you want to. So for those of you, and for those of you all, there's several other people here that are here on a violation of probation for the first time. So listen up to what I'm telling Ms. Irby. I'm going to tell you the exact same thing. First of all, ma'am, you have a right to an attorney with this new charge of violation of probation. You want to have an attorney here? Okay. So the court will appoint the public defender. You got to fill out the form. Okay, so you can do that. The court, because you haven't had a chance to talk with your attorney, I'm going to go ahead and enter a denial on your behalf, as well as the other folks. So you have a chance to talk with them and kind of figure out what your different options are, etc. Okay? Do you have any questions? Okay, so we'll enter a denial, and
Yes, sir.
you got to fill out the form.
Okay, Judge, do you want to set for 8:22?
Yes, that's a good one. Thank you.
9 o'clock?
9 o'clock, 8:22.
Thank you, Judge.
Okay, next is Rebecca Jordan. Okay, state.
There's a lot of
This is case number 2020 CF 2645. My show, first up on a violation of probation.
What's the number on the docket, Judge?
Number 6 on my docket. Rebecca Jordan.
Page 3.
Is it necessary to have a copy of that?
Yes, Judge. This is Miss Rebecca Jordan, case number 20 CF 2645. It's a violation of probation. If she'd like to resolve this today, the state would be
She's
able.
not here.
State would
I
request.
just announced, and she's not coming to the podium.
The state would request a case.
I'm just curious, the order to appear that was talked about in probation is not signed by the defendant. So is that okay? Did she get a copy?
That's a good question, thank you. The probation,
Looking it right up right now, Your Honor.
okay, thank you. before we issue a plea, we want to make sure that the defendant's been properly noticed. That wouldn't be fair.
Your Honor, all I'm seeing in case notes is that it was emailed to the officer in another county in Jacksonville, probation office on July the 13th. So there's no indication that it was actually given to the offender at this point.
I'm not going to order a case. We need to figure out what's going on with this case. What do we need to do? You want to just bring it back on August 22nd and figure out where we're going with this? Whether she's been contacted, particularly if she's all the way over in Jacksonville.
Yes, Your Honor, that sounds fine to me.
Okay, so we'll come back on, we'll just continue this hearing till August 22nd at 9 a.m. Next is Mr. Morales. Morales?
Good morning.
Enamorado?
Yeah.
Okay.
Little
Little bit of English?
It does appear that he needs an interpreter.
Okay.
Is there an interpreter in the building?
From what I was reading on the
She's not 10-6, can you send her up to 3 alpha, just briefly for one. She's in the middle.
at the lectern.
Okay. Just wait one little bit.
10-4.
Wait just a little bit, we'll get the interpreter.
Un momento, siéntese por favor.
Cody Wilcox.
Judge, this is the case where Mr. Wilcox wrote to the court.
Yes. I put this on basically because I needed to get it on the record. I didn't really know.
I do have a warrant for Mr. Wilcox.
Your Honor, you did approve, I believe, his ability to attend via Zoom. Could we move this to the bottom of the docket because I do have a witness coming in?
I'm here.
I'm afraid to ask the question because he's not even here to get him on Zoom. I'm just trying to understand the status. So you need a witness?
Well, Your Honor, I wasn't sure. When he was put on today, I wasn't sure if the court was going to treat his letter as a motion to recall the warrant. So in that, out of an abundance of caution, I did bring my witness.
Okay.
The officer
Your witness is?
The officer who did do the affidavit.
Okay.
I wasn't sure how the court wanted to
No,
treat
I
this.
appreciate it. I just wanted to get it back. I couldn't deal with it in my office. I needed to deal with it on the record. And that's why I just was unclear about where everything was at. So, we need to wait in order. Ma'am, trying to figure out how. I did not know this was via Zoom. Is this via Zoom? Is that what it is?
I don't even know if he's aware.
Yeah.
I sent email to Mr. Wilcox on July 13th, based on correspondence that was filed by Ms. Van Loxtel, and your direction to put it on the docket today, so I did. Did a notice to appear to the email address that you provided, and I did that on July 13th, and it's not back. I didn't see anything in correspondence about the Zoom, Your Honor. I have his correspondence here. He doesn't mention anything about
Yeah, I
that.
don't have anything on Zoom.
And so this is Van Loxtel. I don't think he appeared a year ago. He needs
Can
to be
you come
arrested.
back a little bit? Can you come back to where we can get your testimony or just report what's the situation, counsel? That's why I put it
Oh,
on.
Judge, certainly. So what happened in this case?
He was noticed to be here, he's not here, we're dealing with it.
Certainly.
Go ahead.
So what happened in this instance was he was on probation for the underlying charges of DUI, I believe.
Grand theft of an auto and DUI.
Correct. And then while he was on probation out of Alabama, he picked up a new charge, which was a DUI that resulted in a fatality. That DUI was dismissed out of Alabama. However, it still is a violation of the rules of probation, right, that he agrees to when he signed up for probation. He wrote to you.
What rule that was violated back?
That he violated new law violation. It is, you cannot pick up a new law violation while you're on supervision.
Yeah, but when that's dismissed, doesn't that resolve it?
Not necessarily, Judge, because he signs to the terms and conditions of probation when he starts probation, and one of those terms is a dismissal doesn't necessarily cause the violation to go away. So he wrote to you asking for the warrant to be withdrawn.
Right.
And our position is the violation should not be dismissed in Judge, our position is the warrant shouldn't be recalled at this time, based on the violation still being outstanding.
And his underlying case, did he have a public defender appointed?
I do not have that information, Judge.
Yeah,
Yes, sir. He was represented by Mr. Batson back in 2020.
that was the public defender.
Yes, sir.
I think he was there then.
Right.
Okay. So there's a new violation of probation that's been filed, right?
That's correct.
Okay, but he hasn't appeared yet on that.
That's correct, because he hasn't been served with the warrant.
I'm going to go ahead and appoint a public defender, just kind of so you guys can get at least a little bit of a head start and maybe try and contact him. Because when he comes here, he'd get an attorney appointed. The court's not going to take any action on the warrant at this time. Let's just go ahead and get him in here on his VOP and serve him and proceed from there.
Thank you.
And Your Honor, following more info in the case, there's quite a bit in here. When he violated once already, he did appear in August of last year and did not have counsel. He went ahead and proceeded, and the VOP was dismissed here. For this will be the second violation.
So the court will enter. Do you have the case number, counsel?
Yes, sir, 19 CF 1952.
Correct. Okay.
And Judge, you want to set it for what status on 822?
Well, they've got to get him served. Do we need to have a?
I have a warrant with extradition. I don't know why Alabama won't serve it, but I will make sure to put another note in that he needs to be served on the warrant and extradited.
So do we need to put a date? If we do, we can, I can set it for a time.
Well, but if he hadn't been served, Judge, I don't know if the case is active at this point.
Well, he's got an underlying case that he's operating on, so I'm just trying to get a head start on this thing.
Gotcha.
It's going to be appointed. If you don't, we'll do it provisionally and just so at least you know what's going on. Do we need to set it for a hearing or just wait till he gets picked up?
I think wait until he gets picked up, Your Honor.
Okay, that's fine.
Okay.
Okay, thank you very much.
Thank you, Judge. Can
Mr. Garrett?
Good morning, Your Honor.
Good morning.
Your Honor, on behalf of Mr. Hall, Chris Garrett, on behalf of John Lewis Hall, case number is 20 CF 525, and Your Honor, we're here for a bond hearing today.
You may proceed.
Thank you, Your Honor. Did Your Honor have a chance to review the motion that I filed regarding this
I
case? Thank you, Your Honor. And just to add to it, Mr. Hall's fiance, soon-to-be wife, Tiffany Holcomb, is present in the courtroom. She's back there to my right, Your Honor. We're asking for a bond in this case. The state is opposed To give your honor some more detail about the probation that he's violated here, his original termination date was September 9th of 2022. After speaking with probation this morning, his only remaining requirements were monetary obligations in the amount of $1,178.57. Mr. Hall would certainly be willing to pay that today if it would help him get a bond here. Your honor, we're asking for a bond with any conditions that the court deems appropriate. The new law itself, just to look at the court, I mean, Mr. Hall, first of all, does have a statement he would like to read to the court once I get done, but Mr. Hall does suffer from IED, intermittent explosive disorder. It's a chronic issue that he has. It's genetic. It makes his impulse control is basically lessened, is my understanding of the disorder. He is supposed to be taking mood stabilizers, Remeron, and also basically a Xanax analog. He's not getting that in jail. And unfortunately, before this incident, he had stopped taking that medication because he was in a bad traffic accident. His mother passed away. He should have been on his medication, but he unfortunately stopped taking it. He very much needs it, however. He has been in custody since May 24th, 2022. This is and as far as Mr. Hall's personal life goes, he has a 14-year-old son.
He's been in jail since when?
May 24th, 2022. 2023, Your Honor. Excuse me. I'm sorry. It's 2023. Sorry. He's not been in jail for over. Yeah, we're not just coming here. But he has been in custody, Your Honor. And Mr. Hall does have a statement he would like to read to the court.
My name is Louis Hall. I'm a full-time employee with Coastal Power Sports as a general manager, recently purchased by another corporation. We currently have contracts with all local military bases to service the flatline and training vehicles on Eglin, Harbor Field, 7th Group Special Forces, Florida Fish and Wildlife, and Navarre Beach Fire Rescue, as well as electric motorcycles Panama City Police Department recently purchased from us. Not only is my presence extremely essential for my company, as well as the contracts, but also to provide financial stability for my family. I support 2 children. The oldest is 14 and autistic with Williams syndrome, who lives with his mother and relies on me heavily for my monetary support, as well as many other things. The other is 5 and resides with me and my wife, who are in the process of moving to another home, which has been extremely difficult due to my incarceration. This bond request isn't just about freedom, but being able to provide a proper service for the men and women who fight for us, as it has become nearly impossible to run the business, and for my family who is in need of support and dependent on me. If the court would grant me a bond, I give my word here today that I will make all future court hearings as I have never missed one. Thank you for your time in this matter.
And Your Honor, just last thing from you, just to reiterate that Mr. Hall has never failed to appear for court. All of the new charges, the same thing that he was on probation for. In the new charge, Mr. Hall was on a motorcycle. I understand that fleeing and eluding is inherently dangerous. I would argue that it's slightly less dangerous on a motorcycle. Clearly, he made a mistake. We're not here to justify that mistake in any way. We're just asking that Your Honor grant him a bond so that he can continue caring for his dependents, working for his business. And in the meantime, Your Honor, we are attempting to negotiate a resolution with the state.
Judge, the defense has laid out a bunch of...
let me just ask you this, the violation is, what is the violation, the new law charge?
That's correct, Your Honor. And Judge, the state's position is that the defense has laid out a bunch of great reasons for him not to be picking up new law violations. Specifically, Judge, I'd like to point out that the underlying crime in this case was driving while license suspended and then fleeing and eluding and reckless driving as well. Those were the underlying charges. And how did he violate? Well, he went out and picked up the exact same charges with the exception of the reckless driving. And I'm not going to engage with Mr. Garrett's argument that it's less dangerous on a motorcycle. There's at least one person who's in danger when he's fleeing and eluding on a motorcycle. He could pothole and he could roll. There's plenty of people. I mean, I'm not going to engage with that argument. It's just as dangerous regardless of what you're driving. Now, I understand that he might not be getting his medications while he's in jail, but my counter to that would be he wasn't taking the medications anyway. So I believe he's exactly where he needs to be right now for the safety of the public.
Where are we at in regards to the negotiations on plea?
Your Honor, I believe the current offer from the state was 14 months DOC. The recommendation from probation for the violation in the event that he was found not guilty of the new offense was to convert him to CC for the remainder of supervision, if I'm not totally mistaken there. Yeah.
That's pretty big, isn't it?
That part, as far as the recommendation goes, Your Honor, at this point is kind of
Not found not guilty, that qualification, we deal with most DOTs.
Yes, Your Honor. And, as far as the driving goes, obviously he did make a mistake. Mr. Hall has been in and out of the system for a lot of his life. His license has been suspended. He does have a bad driving record, but his license has been suspended for a long time. As far as what good does it do to him or to society for his continued incarceration, I don't know what exactly that benefit would be. Certainly not to him and to his dependents, who are, the main reason why he wants out here is to take care of his dependents, to keep his employment. Otherwise, he's going to lose those things, cause hardships for other people. And as I said, Your Honor, if this, I wouldn't be standing here doing this if he had ever failed to appear or, something like that, but he hasn't. That has not been his issue. He has had a lot of issues, but failing to appear is not one.
Well, there's two issues here. Failure to appear that's obviously the primary issue, but safety of the public is also the issue that we have to deal with. And that's what the state's not arguing that he wouldn't show up.
And Your Honor, I would add to that he no longer has possession of any vehicle. As far as public safety goes, he does not have access to a vehicle that he owns. He would certainly agree to not drive whatsoever. Obviously, he can't legally do it anyway, but he does not have access to a vehicle at this point.
Problem is that you got a serious charge that the state's seeking DOC. And I don't know that this helps move the ball down the court to try to get out. Based on one of the biggest things we've got to deal with is when a lot of people honestly don't understand it. And I get they don't understand it. It doesn't matter to me. It doesn't matter to the system. When you're out on probation, and you pick up new charges, especially when they're identical charges. You got to look at what the general public's looking at. General public, somebody did exactly the same thing, we're let him out a third time, give him a chance, maybe he'll kill somebody next time. That's the countervailing argument. I'm sure you're not trying to go out and kill somebody. I'm not saying that. And I have no doubt you are sincere in your remorse at this point, but it doesn't take away from the issue. I think we got to deal with the underlying issue, and hopefully you guys can work it out. But I'm not going to issue a bond at this point. I think we got to deal with the underlying issue.
Understood, Your Honor. Thank you. Thank you, Your Honor. I believe that's all I have.
Is Rudy here? Is he ready?
I think he's in the attorney's room, Your Honor.
You want to? Who wants to go? Or who are you sitting in?
Mr. Gates?
Mr. Gates?
Yes, sir. Mr. Medina's talking to clients, Judge.
Okay. Well, Mr. Gates only has a couple, so.
Yes, sir.
I think he's only got two, so.
Yes, sir. Page 9, Dustin Jennings.
Correct.
Case numbers are 22 CF 2957 and 22 CF 2958.
Right.
Mr. Jennings is in custody, Judge, but we ask that he not be transported because Mr. Gates has already talked to him. Mr. Jennings also has a new law violation that's currently set for 8/17 at 1:30, felony plea day. So we're going to ask that these two cases be set for that same time, and maybe by then the state will make a charging decision, and or we may be able to resolve all three cases.
Very good. So we'll continue this till 8:17 and 9.
The plea at this time.
I'm sorry. Did I say 8:17? Is that not?
No, 8:17 is right, but can we set it for 1:30, because the new case is already set for felony plea.
Okay, sure. Good. Thank you for.
We put denial at this time.
Oh, denial at this time.
We'll go ahead and enter denial. That's good. Thank you, ma'am.
And Judge, that's the only one that I saw left.
I think that's the only one that's
Oh.
so.
Well, Your Honor, we do have a bond hearing this morning that you continued from last week. Oh, it's no longer with the public defender, I apologize.
We have withdrawn. Elijah Westbrook's bond hearing was continued. After that date, Mr. Gates withdrew. RCC has it, and I've already talked to Mr. Harper about the case. So that may be.
Is that on the docket today?
I believe it is on the docket, Your Honor, it's just with Mr. Harper.
Correct.
Okay, good. We'll come back on that. So thank you. Good to see you.
Good to see you, Judge.
Mr. Morrow, you want to?
I can call if you out of custody, Your Honor. First one will be Mr. Cameron Benoit. 2 cases before the court, Your Honor. That'd be 22 CF 692 and 22 CF 695. We're going to ask the court to allow us to continue this matter to the earliest date we have in August. We believe that Mr. Benoit will have attained compliance by that time. We'll ask the state to move the court to dismiss the affidavit.
Dave?
Your Honor, that's fine.
So continue it till August 22nd?
That'd be fine.
Yes, Your Honor, I do believe the state's offer is with the term financials to a lien, so.
And Mr. Benoit has paid about $1,000 on his financials since the last court date. He's got about $500 left. We anticipate he won't have an issue finishing it out.
Very good. Appreciate it. Thank you. And that'll be at 9 o'clock.
Thank you, Your Honor. Good enough. Next, Your Honor, will be Mr. Bobby Davenport. This is 20 CF 2964. Your Honor, this is going to be a plea to the bench. There is no agreement between the parties. He's been advised as the maximums, he's been advised as the allegations, he's been advised as a score sheet. I'll pause and give Mr. Davenport an opportunity to sign his plea agreement.
Yeah, she's on her way right now. That's going to be good.
You can hire your own attorney wherever you need. That's not a here, that's just a community judge. May I approach, Your Honor?
You may. There's a score sheet?
Your Honor, the score sheet will be provided at sentencing. Are you wanting to proceed to sentencing soon, Mr. Klein?
You're going to proceed, but I've got to ask him some questions, and partly it will.
I do have the score sheet. I do have the score sheet, Your Honor.
What's the
minimum guidelines are, he scores 41.8 points, Your Honor. So he does not have presumptive minimum prison sentence.
Okay.
And just to illuminate a little bit, Your Honor, why we're pursuing it in this fashion, probation had recommended reinstatement with community control and IOP, and the state is seeking inpatient
What's
treatment.
IOP?
Intensive outpatient treatment, Your Honor. And it's my understanding they no longer offer that in Okaloosa County, so the state is seeking inpatient treatment as opposed to community-based supervision on that basis. So that's the reason that we failed to come to terms.
Because we don't have a program where we're arguing over this and potentially putting him at risk of being sent to a DOC sentence.
Correct.
That makes no sense. It's unfortunate. I'm going to give you a chance to talk in just a second. Hang on. So the offer is an inpatient?
The offer was inpatient. I believe it was Keaton or Phoenix House.
We have no alternative to it?
I believe the alternative was an incarceration type sentence.
No, I understand that. But what you're saying is that they would have offered an intensive outpatient as a solution, as a plea, but you're saying because it doesn't have that, I want to have the state confirm that doesn't exactly sound.
I'm only getting that from the recommendation of the probation officer, Your Honor, not from the state, to be clear.
State's who you're talking with, and it's not probation. And they're the ones that entered the plea with it, isn't it?
I just
need to figure out what's their position.
Your Honor, just to be clear, was the state's offer for him to do inpatient treatment because the violation report states that outpatient treatment has already been completed. That's why I felt like he needs inpatient treatment, was not simply because we don't have an outpatient program. You're disagreeing on whether he might need inpatient treatment or not. Because the VOP report states that the drug and alcohol evaluation and treatment have been completed.
Okay. That's correct.
I believe so. He's been through some outpatient treatment throughout the course of this supervision.
Well, he completed it according to probation. That's what, and then he violated.
With another positive
Another
test.
time. Would you please raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Okay. So, entering into this dialogue with your attorney in the state about the plea, but I need to talk to you, make sure you understand what's going on here. Okay? I mean, look, we're the front lines of addiction in this, right here, in this courtroom, and other courtrooms. We deal with it every day. And we're sympathetic to it. But it doesn't change the law and doesn't change the way, you know, the system works. And I just want to make sure that you understand that by entering into this thing, you're putting yourself at risk, not just for what the state's or probation is, but you're putting yourself at risk to an incarcerative sentence. Do you understand that?
Nah. Yes, sir.
Is that something you want to take your shot, take your chance with? You got a maximum of 6-year sentence here. Do you understand that?
Yes, sir.
And that's what you want to do. Just ask.
I don't.
For me to accept your plea, it has to be knowingly, it has to be voluntarily. I just want to make sure you understand what you're walking into. People are going to plead to the bench with big maximum sentences, and I want to make sure they understand what they're doing, because I don't want anybody, you know, like, oh, what's going on here? Look, you know, what are we doing here? Okay, so you want, we can do one of two things. If you want to, we can accept this plea here today. If you convince me you're doing it freely and voluntarily, or we can pass this over, have some further discussion, see kind of what, see if you come to some arrangement with to get this right.
Yeah, pass it, continue.
Okay. We're going to continue this until August 22nd. And engage with the state on this and try to figure out if you can. And you always have the opportunity to contest this. You can have this. Thank you.
You have the interpreter.
Okay. Mr. Mark, can we jump the interpreter ahead?
Good morning, Your Honor.
Good morning. Thank you for coming down.
Yes, sir, of course. That's what I mean.
Would you please swear the interpreter?
Do you agree to accurately interpret from English to Spanish, Spanish to English, the matters brought before the court today, so help you God?
I do.
Okay. Mr. Morales, you have been charged with a new count of violation of probation. Do you understand that? What's the basis of the violation? Is there a new law charge?
Sorry, Your Honor.
21 CF 1430.
Failure to complete his community service hours, failure to pay constant supervision, and that is it, Your Honor.
Yes, I did pay everything. I have some proof here.
What about community service hours?
I told my official that was supervising me, Your Honor, that I was going to pay for those.
Is somebody here from probation weigh in on this?
Yes, Your Honor, I'm checking into it right now.
Take your time.
And just so you know, Your Honor, the recommendation was for him to be terminated. The officer does state that he completed anger management and paid all of his court costs. I'm just unsure about the community service hours.
Tell them that probation is checking into it to see what's. So your understanding, Mr. Morales, that you paid for all of their community service hours?
I already paid for it, Your Honor, yes.
We'll check. Stage in your records, you're showing that it's still outstanding.
It's showing on the violation report that it's in violation status, the community service.
All right, so Your Honor, we are showing that he paid his cost of supervision and the initial court costs were paid. However, there has not been an additional account set up with the clerk for community service hours to be bought out. He did have that option on his probation order. He had 100 community service hours. So that would be an additional $1,000 that he would need to pay the clerk.
I thought you said you believed you paid for those already.
I'm not certain, Your Honor. I just have receipts here of what I paid. And I was under the impression that those hours were part of it also.
What I'm going to do is I'm going to. Does probation have somebody that speaks Spanish?
We usually
failure to communicate here, I think.
Yeah, normally we have either officers in another office that we get a hold of, or there's a phone number that we call in and do it through the phone.
So, I'm going to continue this hearing until August 22nd at 9 a.m. And between now and August 22nd, you need to go over to probation and find out exactly what you owe, if anything, or that you paid for it. You've got your receipts. Sit down with them. They'll work it out. If you still owe some money, they'll tell you how much you owe. And if you can pay it off by August 22nd, it'll be dismissed. But if not, we'll proceed at that time, okay? Okay, question? Thank you.
So it's just to continue.
Just continue to August 22nd. Mr. Cobb, were you supposed to have one? Do you have anything on the docket?
Mr. Miles,
Yeah, I got a notice last week that it was scheduled for the 18th, but then I didn't see his name on the list, so I started looking through the clerk record, and I see 2 dates, the 17th and the 18th, so I don't.
What's the case number?
Yeah, do you have the case number?
That's 1317.
Oh, hold on.
Yes, sir.
What's the first 2 digits? What year?
2020, CF 1370. It was a Nelson.
Wait.
Yes, sir. Yes, sir. I was the one who did the email back and forth with you, Mr. Carr, and was not able to appear on your, Mr. Miles was an inmate who appeared without Mr. Cobb because Mr. Cobb could not make it, and you continued it to today for the Nelson hearing. As far as...
How come he's not on the docket?
No, I'm so sorry. You then did a motion for continuance.
Yes, ma'am.
And
Yeah,
it's
and I
now...
signed it.
Yes, sir.
Okay,
It's now set for a motion hearing on the Nelson, August 17th, but the pretrial conference is on August 16th. Because last week had to be continued to the August date, it went past your pretrial conference.
Okay. That's the earliest we have after today is August 17th. So the Nelson hearing will be on August 17th. If you'll put in a motion on the pretrial and explain what we're doing, that we have one the next day.
Yes, sir.
We'll continue it to the next cycle, so you don't have to come on the 16th. Well,
Yes, sir, because you have one of the dates that I couldn't do.
right, that's all right. So the pretrial is the 16th?
Yes.
Yeah, so you just need to file something, or you need to be here on the 16th as well, but that would be a wasted hearing, and we don't want you to have to do that.
Yes, sir.
Okay.
Thank you.
But just explain it in the motion, so it'll key me to remember.
Yes, sir.
Okay?
Thanks.
Thank you.
Just wasn't comfortable with continuing the pretrial conference without
That's perfect. No, you're good. Thank you very much. Okay, thank you, Mr. Collins.
Thank you, Judge.
Mr. Morrow, you want to do some more?
Certainly. Mr. Christopher Wilson. Brian Morrow for Mr. Wilson, Your Honor. This is 21 CF 860. Mr. Wilson is still chipping away at his conditions, Your Honor. The state's...
Trying to find your case. Wilson?
Yes, Your Honor.
Go ahead.
He brought with him today proof of his community service work completion, as well as a proof of some payment of some financials. The state's current offer is to revoke and terminate his supervision and sentence him to 6 months in the county jail. At this time, I'd ask the court to allow us to continue this to the August date, and it will likely either be a plea straight up or a plea to the state's offer at that time.
We'll continue this to October 22nd at 9 a.m.
I don't have an October 22nd either.
Did I say October? I said August 22nd. I'm sorry. You said, did I say October?
Yes, sir, you did.
Still mid-morning.
We'll get through it,
No
Judge.
excuse. Okay. Thank you. Mr. Moore, I have one other one that's out of custody of yours. Is it Donald Frazier?
Don Frazier. Your Honor, Mr. Frazier has been passed to complete several times. He is
on in years. He relies on others for transportation. He's got some significant health issues. I don't know why he's not here this morning, Your Honor. This was a case
pass
where...
over and see if he'll maybe try and contact him, or...
I will, Your Honor. When I go back to my office before the afternoon docket, I'll try to figure out what's going on. I think I also have Renee Hendricks on the docket.
Okay.
I did not see Ms. Hendricks in the courtroom. May I have a moment with her before we proceed?
Why don't we go ahead and get Mr. Harper
Certainly.
to talk to your client. Mr. Harper, you want to?
I have been out of custody. Can I get the date on Donald Frazier, Judge? I didn't hear you.
I'm sorry?
On Mr. Frazier?
Frazier, we're just passing over it for this morning. We're going to come back this afternoon, and hopefully you can track down his client.
Judge, I do have one out of custody, Trevion Braxton. He's number 11 on the docket. He's present and approaching. He is before the courts on a number of offenses. 22 CF 739, 22 CF 2943, and 23 CF 126. Judge, this was set for status. I think the state and I have talked. They've conveyed a potential resolution. I've conveyed that to my client. We just need some time to think about it. If I can move this to the August pretrial, I'm hopeful we can resolve that cycle.
You want to come back on to the pretrial, or is the new law charge on the pretrial? Is that why you're?
They're all new charges, Judge.
Okay, so August 14th then? Let's see. Yeah, August 14th to 9 a.m.
Yes, sir.
Okay, thank you.
Sorry, that's really what we're looking for. All right.
Elijah Westbrook.
Okay.
Judge, this is Mr. Westbrook. He's before the courts. He's number 17 on docket 23 CF 1148. Judge, I was appointed to this case last week. It looked like previous counsel had filed a motion for bond. We would be adopting that bond motion today, and we would be asking for a reduction in his bond. His bond currently is $50,000. My client is requesting a bond in the amount of $2,500 cash or professional. He does have support in the area. His father has arranged for him to attend a mental health and substance abuse evaluation in Lakeview in Pensacola. The anticipation is that upon his release that he be sent there to deal with both his mental health and substance abuse issues, not as a condition of any probation. It's just something that they're electing on their own to do. He is 19 years of age, and he would be living with his father, Mr. Westbrook, were he to be released.
Judge, my position is the same as it was last week. I'm opposed to any bond reduction. Last week, the court did express some interest in the evidence in the case, specifically regarding the video. I did go review the video. It's my position that you can clearly see him putting some toilet paper into the trash can that was already on fire at that time. However, the court does not need to take my word for it. I've arranged for the officer to be here. Officer Atkins is here to testify if the court would be interested. But clearly he was participating along with other people in his block to light this fire. That is the state's position.
And Judge, I'm in an unfortunate position that I was just appointed. I don't have access to all of the discovery at this point. I have not seen this video, but it's my client's contention that he did not participate in the extent that the state is alleging.
Can we have a condition of pretrial release that he obtain these evaluations?
Absolutely, Judge. That can be a condition of bond, yes, Judge. And that his father would be responsible for taking him there. I think his father's already amenable.
Follow any recommendations that, does he have, say he has appointments? They're pending? He probably doesn't have appointments, but
it's my understanding that he was sentenced and he had an EOS, I think, at the end of June.
What's EOS?
His end of sentence for that particular sentence was going to be in June 30. But for this issue, he would have already probably attended his, but now it's being kind of held in abeyance until he's released. So once he's released, that would trigger him to go attend this evaluation.
The state does have a bond that he's released. Is there any other requirements such as a GPS monitor that the state would request?
Well, certainly, Judge, if the court wants to lower his bond to something he would make, I would ask for a GPS monitor. But Judge, I want to be clear, the offer on the table here is 10 years. He has a substantial exposure.
What does he score?
I believe, Judge, he scored something in the realm of 7 years. So the offer was 10, Judge, because this is a serious felony. And I would point out to the court that would be my argument, Judge.
Mr. Harper?
And may I just continue on the evidence, Judge, because it was brought up at the last hearing. I know that the prior defense attorney was saying that you really can't see much in the video, and that this defendant was behind bars when the fire started, and the fire started outside the bars. What I would convey to the court is that in this video, what you see is the fire gets started in a trash can, it's carried up to this defendant's cell, and you see a lot of movement around the cell, and then the fire gets bigger, right? And if the court wanted to hear testimony today, the testimony, I believe, would say that he was throwing wads of toilet paper into the fire, and he was participating in the act of causing this fire in the cell block, and then his co-conspirator went and barricaded the doors. So I would say that this is a pretty serious felony. I think 10 years is appropriate.
So, because of the timing of this, we don't have time to have an extensive hearing today. If you want to have testimony, let's go ahead and schedule this for testimony. I think in order to do this, I think the state has a right to call witnesses, and so we can either let's try and, what do we have in the afternoon? The 17th or the 22nd?
On the 17th, you have 8. On the 22nd, you have 5. On the 24th, you have 2. And this is office.
Correct.
I have 2 on the
Well, if you want to do a hearing, we'll have some witnesses. Let's bring it back on August 24th at 1:30.
Thank you.
And is that in the afternoon, Judge?
That would be in the afternoon, that's correct, at 1:30.
Ms. Henson?
Thank
you. Judge, this is Pamela Henson. She's before the court on 23 CF 818. She's before the courts on a motion for bond reduction.
Hold on a second. Do you know what number?
On my docket, Judge, she is number 13. I apparently have a weird docket.
No, you've been right on it so far. Correct, 13. Hold on just a second. Go ahead.
Judge, Ms. Henson had a bond motion provided by previous counsel, and I can't tell if that motion was ever heard. It looked like it had been continued. I would adopt that motion for purposes of today. Her present bond is $10,000 cash professional. She is asking for a bail in the amount of $1,000 cash professional. She was employed, and she would be living with her father were she to be let out on bond. She anticipates residing in Mary Esther. She does have a associate's degree, and it looks like there were 2 failures to appear, but they were later recalled. She was in custody. So she would ask for a bond reduction in this case. She understands, given the nature of these types of charges, that she would have to have a condition of no contact with the victim in this manner, and she's absolutely okay with that. She's also amenable if it's required by the courts for a GPS monitor, but she would ask for the lowest permissible daily rate, which would be $1 a day.
state?
One moment, Judge, I'm just checking something. Judge, I would say that the state is opposed, that she does score 15 months. That is the guidelines, and that's the offer in this case. I would note that she has prior violent criminal history, and that she was threatening to kill her roommate in this instance. The roommate was the victim. I spoke with the victim, and the victim is opposed to a bond and was in support of the 15-month offer.
Who is the victim?
I never did. The victim's name, one moment, Judge. The victim's name is Chad Crumbly. He works locally at the military base.
If the court does have a bond that you can meet, do you have any other, does it say have any other requirements for?
I would ask that the court keep the bond at its present level. If the bond is reduced, I would ask for GPS requirement, no contact, no contact with the victim. And give me one moment, Judge. I believe the victim has vacated the residence, but I want to provide that court with that information.
Did you say that the
I rented to him,
the
sir.
offended is going to be?
She'll be residing with her father, Judge.
So she's not going to be in the residence?
No.
I have no problem, no contact, Your Honor. I've been here for 101 days, and it was a mental health issue.
Judge, I can confirm that the victim has vacated the residence, and he did indicate that he would be safe if her bond was reduced. However, the state is still opposed to it.
Court will grant the request for bond reduction to $1,000. The court would have as a condition of the bond that there be no contact. Now, this is one-sided contact, ma'am. You need to understand. Listen to me. This is important. If the victim tries to contact you, you're the one who's going to be in violation. So you got to walk. If you bump into him in Walmart, you got to walk away from him. If he tries to call you, you can't accept this call. Do you understand? Stay away.
He broke in on me.
Listen. And the court will also require a GPS monitor at the lowest rate available.
Thank you. I've got the cash, and I'll cash out the front so it'll go toward my court cost. And I thank you very much, and I'm very grateful today.
Sorry.
Is pretrial services involved?
Yes.
No, I'm not. I'm afraid of that.
1,000 cash or professional.
Thank you. I will cash out front order to go to my bond.
What was the next court date? I'm sorry? The next court date, Judge?
I think she was scheduled for.
Set for August 16th, Your Honor.
So we'll change it to August 14th.
Shannon Locke.
We need to make sure she knows that it's August 14th, so we don't, Mr. Harper, so she doesn't get
Yes,
twisted
sir.
up on.
I've given her my contact information just now, and I've advised her to reach out to me. Judge, this is Shannon Locke, number 16 on the docket. She's before the court on 22 CF 3003. Your Honor, we were just appointed to this case. Just a moment. Judge, if we could have the next available miscellaneous, this is a VOP, a miscellaneous date. I think my client is amenable to a plea. It would be an incarcerative plea to revoke a term. We just need to get the state on board with our numbers.
Very good. We'll continue this until, has she entered a plea?
If she is not, Judge, we would consider denial.
And we'll come back on August 22nd at 9 a.m.
She was never filed.
Right this way. Really keen, really keen person.
Judge, this is Willie King. He's number 15 on the docket. Judge, Mr. King is before the court on 17 CF 3361, 18 CF 535, and 19 CF 1934. Judge, the state and I have been in communication, and they've conveyed a counteroffer to us. We've actually conveyed a counteroffer to them. I think that we're actually closer to a resolution than we ever have been. If we can set this for an afternoon evidentiary hearing, I think that's either we'll have a hearing or we'll enter an amended plea, but come to a resolution next, whatever the date is, Judge.
August 24th.
And can that be in the afternoon?
That is in the afternoon. How long would you anticipate the hearing
If there were to be a hearing, I'm anticipating that the state will call one witness, Mr. Elwood. We would call potentially two witnesses.
Very good. August 24th at 1:30.
That's fine.
And that'll be for an evidentiary.
I actually tried to do that, but he said it's fine.
I'll wait till that turns Arnold.
Judge, this is Stephen Arnold. He's number 9 on the docket. He's before the courts on 23 CF 1068. I filed a motion to reduce his bond.
What number?
It's number 9 on the docket, Judge.
Okay, go ahead. Sorry.
Judge, Mr. Arnold is before the courts on a motion to reduce his bond. He's charged with offensive possession of controlled substance, tampering, and possession of paraphernalia. It's our argument that he was just a mere occupant of the vehicle. It was not his vehicle. He was never found in actual physical possession of any of the alleged contraband or narcotics. There's no evidence to substantiate that the officer in question observed him tampering or otherwise destroying evidence. He was employed by the Fort Walton Destin Airport at the time. Hopefully he can return to that occupation, but he was employed there, and as a condition of that employment, he's regularly drug tested, has never tested positive. He currently has a bond of $3,500 on the possession of controlled substance and $2,500 on the tampering. Those are both cash or professional bonds. He's unable to secure his release. He's asking for a signature bond in these cases.
Steve?
Yes, Your Honor. The state would agree in this case, and I did speak to Mr. Harper about reducing the cash or professional bond that he has right now to $1,500 per cash or professional per the counts. However, just so the court is aware of the state's view of the facts, the officer conducted a traffic stop. The K-9 unit was then called to conduct a pre-air sniff of the car, probable search of the car. There was a ripped piece of bag and next to a pile of a white substance which tested positive for fentanyl. That substance and pile was located between the front passenger seat and the middle console, and there was some underneath the passenger seat. Mr. Arnold was occupying that passenger seat, so it is the state's contention that he did have possession and the ability to control that substance.
So I'm unclear about what the state has offered by way of compromise on the amount of the bond. You said $1,500. Is that for each of the two charges?
I'm sorry, Your Honor, give me just a second. I need to.
He's got 35 in one and 25 for the other. So you're okay with 1,500 for each?
Yes, Your Honor, I am okay with 1,500 for each county.
Charlotte?
Your Honor, my client advises he's amenable to that modification if the court accepts it.
The court will modify the bond downward to $1,500 cash or professional for each of the charges.
Thank you.
Thank you very much.
Your Honor, is that's with pretrial services, right? I just want to make sure that's the correct.
What type of pretrial service for what purpose?
Your Honor, the state would like reporting pretrial service for him.
Your Honor, I guess my client misunderstood what cash professional meant. The issue is that a bondsman, because he was at one point a resident of Louisiana, they constituted the flight risk, and so they're less amenable to extending him a bond, meaning that it's less likely that he'll get a cash and professional release on bond. If the court were open to a signature bond, Mr. Arnold, if he's able to return to his place of employment, should be able to afford a GPS monitor if the court has some concerns that may be able to alleviate some of the concerns about his presence and whereabouts while out on bond. He's a recent move from Louisiana to this area about 2 years ago, Judge, and that's all he wanted to convey to the court.
The court will issue allow him to have a signature bond at the same amount that he has the cash professional. So these are signature bonds. So if you don't show, you're going to be hit with a total of $6 grand.
Yes, sir.
Big time.
Yes.
They'll be tracking after you hard. So that'll be a signature bond with the condition that there be a GPS monitor that will allow it to be under pretrial services and give the state some comfort level that Mr. Arnold was staying on patrol.
Thank you, Your Honor. We appreciate that. And Your Honor, is that ordered at the amount usually?
The lowest possible amount.
Okay, that's $1 a day. I just want to make sure, since he has the services of conflict counsel, that it's an amount that won't be prohibitive to him having.
And this case is already set for August 14th.
Okay. And this is already set for August 14th, Mr. Arnold, 9 a.m. So make sure to stay in contact with your attorney.
Yes, sir.
And Judge, for the record, I've provided my contact information to him.
William Bentley?
Judge, this is William Bentley. He's before the court on 23 CF 624. It's number 10 on the docket. Judge, we had left this up for status to see if we could come to a resolution today. I've spoken with the states. I think they would like to speak to the victim in this case some more. The victim has requested charges be dropped, and it's our position that that should be a potential resolution to this case. I think the state at this time is unwilling to agree to that. And so it would be our contention that if we cannot come to a resolution next cycle, we'll be leaving it set for trial. But I think at this present moment, we're not in agreement as to a plea.
Okay, so we'll continue this till August 22nd. We'll either have an agreement or we'll go to an evidentiary. We'll set an evidentiary hearing at that.
Your Honor, can we set it for the pretrial?
Sure.
Is that the 16th?
Yes, it is. Okay, so we'll set it for August 16th, which is pretrial.
Michael Jenkins?
Judge, this is Michael Jenkins. He's number 14 on the docket. He's before the court on 22 CF 2308. Judge, this is a motion for bond reinstatements From a factual perspective, what had happened is that Mr. Jenkins was out on bond in 23 CF 314. He was out on bond in this case, rather. I apologize, I misspoke. He was out on bond in this particular case. He was subsequently arrested in 23 CF 314, which then revoked this bond. My client is a resident of this area. He was employed at the time of his arrest on both of these cases, anticipating going back to that place of employment to resume employment. He has no histories of any failures to appear, Your Honor. He would be amenable to a GPS monitor at the lowest permissible daily rates if allowed out on bond, but he would like the option of contesting these charges while out of custody. It's our intent to file a motion to suppress. We're not yet completely done with that, but we'll be filing a motion to suppress in these matters and having that set for a hearing as well.
Okay. Judge, I want to be clear what happened here. He was arrested on these charges of amphetamine trafficking and then also having possession of controlled substances on him, and that happened in September last year. And then only a matter of months later, he could pick up more amphetamine trafficking charges, and also this time he was found with cocaine. So it's the state's position that if we release him on bond, he's just going to go out into the community to do who knows what and put more people in danger with these substances. So for those reasons, Judge, I would ask that the bond stay exactly where it's at because he's exactly where he needs to be.
And our response to that, Judge, is that these are still allegations at this point. My client is presumed innocent until proven guilty, and he would like the option of contesting these charges and defending himself while out of custody.
Well, you do, there has been a probable cause to that, and when you are out on probation and you pick up more charges, identical charges, you're pretty well guaranteed you're not going to get out of jail. Of course, denying the motion to reinstate bond.
You know. Judge, for the record, I think he understood you to mean that he was on probation, but he's not on probation. He was out on bond while he's alleged to have committed crimes.
Right. He was out on bond on the first charge, and then he picked up the second charge. Excuse me, not a probation. You've been charged with identical charges. No, you can't. Court.
I believe he's set for the August pretrial, Judge, already.
August 6th.
Terrance Wilson.
You have an out of custody.
I do, Judge. If I can address her after.
Okay.
Judge Rudy Harper, on behalf of Darius Wilson, he's before the court on 20 CF 998, 20 CF 999, 20 CF 2791, 21 CF 1350, 21 CF 1490, 21 CF 2700, and 22 CF 189. Judge, these are violations of probation. I see some technical violations. I'm still in negotiations with the state. We're attempting to resolve this. I spoke with my client. His concern is that he's currently enrolled in school, and he's trying to get his bachelor's degree completed, and he's worried about tuition. So if it's possible to have this scheduled for a date in July, I'm not certain if there are any miscellaneous court dates left in July, but it would be his request to set that for the next available. I'll continue talking with Ms. Bossow if we can come to an agreement. I'm not certain if we have that as an option in July, but...
So are you saying that you're wanting to set it there because you believe that you guys are lighting up? Counsel? You guys are lighting Right, you're being amplified. My question is are we putting it out to July in the hopes or anticipation or hopes that it would be able, some of these technical violations would be able to be resolved, i.e. paid during that period? Is that what we're waiting for?
What I'm hoping for is to have the option of talking with Ms. Bossow. She's obviously not present, but having the option of talking with her because these are just technical violations. There's no new law.
Technical, you're talking about, what are the technical violations?
There's a
Mainly fees, or is it?
One of the allegations that there was a positive drug test and that he was outside of his accepted positions while on GPS monitor.
Right.
So there's no allegations as to a new law offense or anything of that nature. I'm hoping that Ms. Boston and I can talk this month and have a hearing just for status this month, see if it's even remotely possible to resolve it this month. And if it's not, I understand if there's no scheduling
We
available.
don't have anything in the law. This is the last miscellaneous docket. There's no new law charge, so we can't do it on the pre-trial.
Is there any, the earliest available in August now?
August 17th is the earliest available.
And for the morning,
And there you go, we got a bunch. You still like 30, yeah, we can still.
does he expect to be a long hearing?
No, this is a status only. It's not an afternoon.
I do have some VOPs that may be added, but right now you only have 20 cases scheduled for August 17th. That's his next one. He doesn't have it.
I understand. If we could set it for that day, Joe.
August 17th at 9.
And then I think the only one that I have otherwise is Miss Carroll. Judge, we had left that set for status. There was an issue with respect to her waiver. I have been in constant communication with her, and I apologize, but the issue is that I don't think that she technically understands how to print it out, sign it, and then scan it back to me. She keeps sending me the same thing that I send her.
So what are we waiting for?
The court had requested proof of the waiver because it had not yet been filed, but she's obviously not present. She's out of state. But I have been in constant communication with her, and we have been attempting to resolve the issue of the waiver to file it. She's taking pictures of her signing it, but it's in a format that I cannot file because it's a picture, and it's frankly crooked. But she has signed the waiver. I'm asking if we can set this for the pretrial in August, Judge. Based on the state's offer, I think it's possible we can resolve it on that date anyway. But
we'll continue to the pre-trial. Is this a new law charge?
Yes, sir, it is.
Okay. We'll come back on August 14th at 9 a.m.
Thank you, Judge. And I think that's all that I have.
Tomorrow, can we, I know Mr. Medina, you got a few cases, you're pretty much, you don't have many, mainly Mr. Medina's. Can we take?
He's got more inmates than Mr. Medina. I got Mr. Medina ready to go.
Can we take a morning break, and then we'll come back and we will finish up.
And Dixie is A/B preeminent rated. Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045. Days Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at DaceTirePros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestview.agent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hi, I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Bad Boys Juicy Beef and Tasty Bird is located at 482 North Wilston Street in historic downtown Crestview, just 1 block from the courthouse. We open at 10 a.m. with amazing lunch specials until 2 p.m., serving incredible burgers, wings, sandwiches, and appetizers. Join us for happy hour Monday through Friday from 3 p.m. to 6 p.m. Hope to see you soon.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045. Days Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at daystirepros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hi, I'm Amanda Gaskin with Bridgeway Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Bad Boy's Juicy Beef and Tasty Bird is located at 482 North Wilston Street in historic downtown Crestview, just 1 block from the courthouse. We open at 10 a.m. with amazing lunch specials until 2 p.m., serving incredible burgers, wings, sandwiches, and appetizers. Join us for happy hour Monday through Friday from 3 p.m. to 6 p.m. Hope to see you soon.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045. Days Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at daystirepros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestview.agent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hi, I'm Amanda Gaskin with Bridgeway Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Fat Boy's Juicy Beef and Tasty Bird is located at 482 North Wilston Street in historic downtown Crestview, just 1 block from the courthouse. We open at 10 a.m. with amazing lunch specials until 2 p.m., serving incredible burgers, wings, sandwiches, and appetizers. Join us for happy hour Monday through Friday from 3 p.m. to 6 p.m. Hope to see you soon.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m.
Have a moment before we send him back here on.
are you waiting on?
I'm waiting on records from Bridgeway, Your Honor, so for my
Is
expert.
that part of the
Yes, Your Honor. Well, it's going to be to provide the court with downward departure grounds with competent substantial evidence in the sentencing hearing.
Okay. Very good.
Thank you, sir.
Thank you.
Jimmy Case.
Ryan Marr for Mr. Case, Your Honor. This is 22 CF 1820. This is going to be a plea to the court. There is no agreement. He does have a 30-month suspended prison sentence. He's been advised of the state's offer, which was to impose the sentence, and I'll pause and allow him an opportunity to sign the plea agreement, the written plea.
What's the score sheet? The minimum guideline?
Yes, Your Honor. He does, as Mr. Amaro said, have a suspended sentence. So that would be the maximum incarceration the court could sentence him to.
What is that?
I think it's 30 months.
You said 30?
30, yes, Your Honor.
And Your Honor, his guidelines are 23.325 months.
And what is the state's position?
Your Honor, the state's asking for the 30 months to be unsuspended.
May I approach, Your Honor?
You may. So would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
Now, I understand why you're pleading to the bench. State's capped out at 30 months and they're offering you 30 months, so I completely understand why you're trying to get a downward departure, but you do understand that this will be a final resolution of your case and you're waiving the right to contest this? Do you understand that? You're waiving the right to contest this violation of probation?
Yes, sir.
Okay. Or you have that right. You're looking at me with a blank look on your face. I want to make sure you understand what we're doing. So you've got violation of probation, and the state's made an offer, and which I understand you may not like, but by entering this plea here today, you're waiving the right to contest, to have a go to a hearing and say, I didn't do this thing violation. You got to prove your case. You understand this?
Yes. May I say something?
Sure.
Yes, sir. My understanding when I signed the plea that I was pleading out to 30 months. I didn't know I only scored out to 23 or 24 months. So.
Are you saying you
That is, you're raising a very important legal question that needs to be directed to your attorney.
Yes, sir.
Not to the court, because
no, I'm sorry.
Well, I'm just telling you.
Yes, sir.
I mean, kind of cow's out of the barn on that one. And I don't know if there anything can be done, even if there was a basis for it. I don't believe that, but that's a question, a legal question, and it's a question that you probably need to have answered in your mind before we enter into this plea, right? Yeah.
I didn't know. I'm saying you before I assumed this. I didn't know that scored out to just 24 months. I wouldn't have signed that 30-month cap. Why would I go that much further? Yes, sir. Okay.
But you do understand that the 30 months suspended sentence is out there. You understand that?
Yes, sir.
And you, in order to go below that, your attorney is going to have a downward departure. That's a very, certain requirements in order to have, that's a technical term, downward departure. Have you gone over that issue with your attorney? Make sure you understand it.
I want to be clear what the defense will be asking for. He's not going to be presenting downward departure grounds. He's going to be asking the court to reinstate his probation while on the project.
Very good. So he doesn't need to have that. Okay. So do you have any further questions regarding what's going on here with this plea to the bench? You do understand your risk for to have the suspended sentence, basically unsuspended, sentenced to 30 months. Do you understand that?
Yes, sir.
You all will get credit for time served if that's what happens, but that's what is really at issue. Very good. Based upon that testimony, the court will enter a plea to the bench. And we'll have to set this thing for a sentencing hearing. So how long is this hearing going to last?
There'll be some brief testimony, probably from Mr. Case. We may take testimony from someone from Project Hope, but not necessarily. Either way, I would anticipate less than an hour, Your Honor.
I would think less than an hour, Judge. If the state calls a witness, it will simply be a probation officer. I will not have any other witnesses for this violation of probation.
No, sir. On August 17th, the hearing just got added today by Mr. Medina for Cole at 2:30, making it now a total of 9.
How was it added? Don't we have it added in?
So that has now gone up. Are you aware of that, Mr. Medina?
I filed a motion to dismiss, and my assistant coordinates the scheduling things, and that's apparently...
That's somebody with the clerk. Clerk shouldn't be adding it.
Can you please ask?
I don't understand what the question is.
Well, I told Judge earlier today that he only had 8 on August 17th, and I just checked again now, and he's up to 9.
Your Honor, I'm not clear.
That's not...
It's okay. I'm trying to...
I don't understand what is being asked. I really don't understand. Who are we supposed to clear that with?
Eileen.
With the judge's assistant? Okay, my assistant presumably knows those processes and follows them, but I guess it is.
I just wanted to make sure. I didn't know if you knew.
I knew I filed a motion to dismiss.
I don't believe Eileen, because Eileen doesn't know how many. I don't think Eileen is clearing these.
Then it's the clerk, and if Vicki would like to contact me, I just want to have my bearings straight in court when I'm giving out these dates, that's all.
I mean, there shouldn't have been one added. Whoever added it shouldn't have been added.
Your Honor, my assistant...
And I'm not mad, we're trying to figure out process here. I'm not...
Exactly.
Don't worry, I'm not mad. I'm not trying to defend my judicial assistant, but I'm almost certain that she didn't, because she doesn't know how many cases are on that day. So she absolutely wouldn't be the one who's...
All right, for the 22nd, I show that you're up to 5. So if you'd like to put this on the 22nd.
Okay, we can do it on the 22nd.
I apologize, Mr. Medina, I just didn't.
No, I apologize for,
No, we'll try and get it.
We'll straighten it out. I didn't mean to imply anything
It's a
that
process.
the judge's assistant said anything. I just know we're trying to do what we think is right. We'll do better. Thank you.
No. You're,
It's what you said.
Yes,
so,
ma'am.
I'm just trying to stand it all out.
I wouldn't even, I'm not even saying anybody really made a mistake, maybe just a miscommunication.
This will be at 2:30.
Correct.
What date did we give, Your Honor? I'm sorry.
22nd of August.
Anybody else?
Joshua Cooper.
Ryan Morrow for Mr. Cooper, Your Honor. This is 20 CF 72. I believe this is the first time up for Mr. Cooper. We'll enter a denial for the record if that hasn't already been done. The state has made an offer of guidelines in this case. The defense is going to seek some evaluations from Phoenix House and Project Hope, and we're also going to have him looked at for drug court, and then we'll come back in August, let the court know which direction this is headed, Your Honor.
So we'll continue this to August 22nd. We'll enter a denial. It's not already been in. 9 a.m.
We'll come out and talk to you too, okay? Should come in.
Giles?
Ryan Marlowe for Giles, Your Honor. This is 20 CF 1221. Unfortunately, the records that we were looking for having passed this case from the 11th have still not come in. We're going to have to ask the court to continue this to our earliest August date. I do anticipate we'll have them before then.
Okay. We'll continue this to August 17th at 9 a.m.
What date did you give, Your Honor? I'm sorry.
August 17th at 9 a.m.
Robert Hall?
Ryan Morrow for Mr. Hall, Your Honor. This is 23 CF 315. Defense is going to request this matter be set for evidentiary hearing.
How long do you anticipate it taking?
This one, Your Honor, may be longer because essentially what would need to happen would the state will have to come in and essentially prove the new law violation at that lower evidentiary standard. So, this one will look more like a full-blown judge trial on the new law violation in Santa Rosa County.
State?
That's correct, Judge. I believe that it would be a longer hearing. If you could set us out towards late August, I think that would be sufficient time to get my
We have no time in August.
Okay, that's fantastic.
September 12th at 2:30.
All right, I'll get my subpoenas out.
Hopkins? Joseph Hopkins.
Ryan Marr for Mr. Hopkins, Your Honor. This is 22 CF 34. The defense expert has requested additional records. I'm going to try to get those for her. I do think it's important for Mr. Hopkins' case. So we're asking the court to allow us to move this to the August date.
Continue to August 22nd at 9 a.m.
Hopkins?
Yes,
correct.
Andrew Keys?
Ryan Morrow for Mr. Keys, Your Honor. This is 23-506. This is going to be a plea to the court with a 12.1 month cap on the incarceration aspect of the sentence. He was previously adjudicated. Pre-sentence report will be waived. I'll pause to give Mr. Keys an opportunity to sign.
The state's agreement?
That's correct, Your Honor.
Cap?
At 12-1, POC.
Mr. Keys, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God? I do. What is the guidelines, minimum guidelines?
There is no minimum guidelines, Judge, but he does score 42.3 points, so he's real close.
So, Mr. Keys, you heard your attorney state the terms of the plea agreement. It's use the common language, plea to the bench. So you're agreeing basically to resolve this case, everything except the sentencing, which is not determined at this point. There is a maximum of 12.1 months in DOC. That would be the max. It could be something in the county jail, it could be credit for time served, or it could be some type of probation. Do you understand all that?
Yes, Your Honor.
And you believe this is in your best interest to enter into this plea?
Yes, Your Honor.
You understand that by entering this, you're waiving the right to go to a contested hearing and say this didn't happen, and the state's got to prove their case. You understand that? You believe that's in your best interest to do that?
Yes, Your Honor.
Have you had all your legal questions answered concerning this plea agreement?
Yes, Your Honor.
Obviously, you've read the plea agreement closely and you've talked to your attorney about it.
I have. Yes.
Based upon that testimony, the court will accept your plea to the bench with the 12.1 month cap on incarceration. Try to figure out when we're going to have how long of a hearing we.
This one will be brief, Your Honor.
One question I have is whether we have any at one time in August.
The August 24th date?
How much is, what do we have on the 24th?
And that starts at 1:30.
Right.
And I believe that it's now at 5. So this would make 6.
Okay, but that'll be.
It starts an hour early at least. Okay.
The August 24th at 1:30. That'll be for sentencing.
Tyree McClendon.
This way, Mr. Clinton. This one, please.
Ryan Morrow for Mr. McClendon, Your Honor. I've spoken to the state on this. We're trying to get him into the Veterans Treatment Court program. I'm hearing from Ms. Sharpless that she may not be willing to sign off on that. I've not yet been told the reason. I think he's entitled to at least consideration based on his service and his treatment needs. So I'm going to ask Ms. Sharpless to expound upon that if she's willing to. If he's not going to be allowed to go to Veterans Treatment Court, we need to pull his matters off the
Is that a firm
docket.
decision that's already been made by the state that they're going to close?
Well, Your Honor, based on the number of cases that he had open and the amount, I think he had like 6 cases open. I know there's one VOP in each case.
Well, they're all VOPs. Is the state saying that the number of cases is prohibiting him from going to court? Because I can tell
No,
you.
not necessarily. I haven't been provided any like proof of service. I know that he is according to what Mr. Morris told me, has a drug problem, but I don't see the VOP as being related to service. That's the issue that I see with putting
Is this open to any further communications, or the state's position?
And I can tell.
Your Honor, I haven't.
I'm just just asking whether everyone's inquired on both ends and had.
Your Honor, if I can receive something from, I haven't received anything from the vet court team that these issues are related to a service or anything like that. I haven't heard anything like that. So I don't know if Mr. Morrow has any of that kind of information that he can give to me. That was the reason I stated no.
The defense is at a little bit of a loss at this point for the intake process for Veterans Treatment Court because
I am too.
I have reached out to Mr. Rivera, who has met with my client and determined that he's at least eligible. He has been twice to observe. I met with the treatment team on Friday, and then everyone said we need to hear from the divisional prosecutor. I've been trying to reach Ms. Sharpless about her position. Then she let me know he used to have a treatment need. I've let her know that he let me know that he does have a treatment need for substance abuse. And I do think he's statutorily at least entitled to consideration. So I'm not hearing.
That's not the issue.
I'm sorry, Judge. What was the question? I'm sorry.
We just need to be clear about the process. The process for entry into vet court, one of the states explain that to me.
Well, Your Honor, usually they meet with Mr. Rivera.
Okay, and that's been done, and according to the defense counsel, just taking his word, we can verify it. He qualifies.
And when the last I spoke with the ASA assigned to vet court, there has not been that much discussion by the rest of the vet court team about whether he's actually a good candidate, because the first step, from my understanding, is meeting with Mr. Rivera, and then it's discussed at staff.
Okay, so we need more time to further review this.
Yes.
Okay. So we'll continue on this.
I just want to say, according to the vet court team, they're waiting on the divisional state attorney. And now I've got the divisional state attorney telling me that we need more information from the vet court team. So as defense counsel and my defendant, we're just trying to figure out how to get there and to get to an answer. What do I need to do to get Mr. McClendon a clear answer on vet court? Because I've already been to the vet court with Judge Mason on Friday.
On June 30th, because Judge Mason ordered that he be removed from your docket and put on vet court. That's how the minute sheet reads, and Mr. Morrow, Ms. Tringus was there that day. And it says...
Ms. Sharpless, did you hear that?
Something was discussed.
Right.
I was moved off my docket. It sounds like you've been accepted in the vet court.
And I can tell the court, for when he was pulled off of your docket, that was done without anybody's, from the attorney's side, say so. That was a surprise to me.
So my
I'm going to
understanding...
pass over this, you guys get together with vet court and figure it out. But I need to get a clear understanding of, I mean, does the ASA have to sign off on it?
Yes. So, and my understanding of the specialty courts is if they are observing the court, they are supposed to be pulled off of the regular docket and put into the court until a yes or no is given. And if a yes is given, then they enter a plea.
So what you need to do is contact the vet court and see where they're at. Because you're saying you need more information from the vet court team? So you contact the vet court team because he's being told he's got all the information from the vet court team and he doesn't know what to do. So you say you're waiting for the vet court team, right?
Your Honor, can we approach? I just don't want to say something.
Okay.
Till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045. Days Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at DaysTirePros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with...
Ms. Sharp was, whatever, just gonna leave. I'm not doing anything with that docket. I'm just coming back on this one. Apparently, I wasn't aware that put on there and then put on hold. I don't know anything about that. All I'm trying to do is give the state the opportunity to follow up, meet with that court to get a clear idea so that she can make a call, which she's required to do before we do it.
So is he going to be put on the court docket, or is he going to come back here?
I don't know whether he's on the vet court docket.
He is.
I'm putting him on August 17th. Come back here on August 17th at 9. In the meantime, you guys get together with vet court. Enough.
Terry Reagan.
Ryan Moore for Mr. Reagan, Your Honor. This is 21 CF 3206 and 2321. This is going to be a plea to the bench. I'll pause and give Mr. Reagan an opportunity to sign. There will be no cap in this case, Your Honor. May I approach?
You may. Is there an offer on the table?
There was, Your Honor. The government wants to handle it.
And is there a score sheet with the minimum guideline?
Judge will provide a score sheet, however, it does reflect 22.6 points with a maximum of 7 years, so he does not score presumptive DOC in this case.
Okay. So, Mr. Reagan, would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
I do, sir.
Okay. So you heard the state's offer. You heard what the score sheet with minimum guidelines. And I assume you also understand what the maximum sentences the court can sentence you to. Do you understand that?
Yes, sir, I believe.
How much is that?
5 years.
7 years.
7 years.
Okay. I just want to make sure you do that, because when you're pleading to the bench, we're pleading the whole range. They're offering you 11 months, and I could say from probation up to 7 years. Do you understand that?
Yes, sir.
You're clear about that?
Yes, sir.
Everyone's just kind of throwing out pleading to the bench like they're getting some that I'm going to be easier than the state. I'm not saying I won't be, but I'm not necessarily going to be easier. I may be a lot harder than the state. I want to make sure that you're clear that this is a true plea to the bench. Do you understand that?
Yes, sir.
Okay. So, did I swear you in?
Yes, sir.
Okay. So I see you signed the plea and sentencing agreement. Did you read this and go over it in detail with your attorney?
I have read it. I spoke with my attorney last Thursday. We briefly went over that, but however, like I said, he's been in front of you all morning, so I haven't had the opportunity to read through it. I did read it on my own, however.
Okay. Well, the main thing I want to make sure is that you've had all your questions answered sufficiently, because you're pleading this thing out. You're not going to be able to back out of this plea agreement, and we're going to be at a sentencing hearing. And I don't want to say, well, I didn't realize that. Okay. So do you feel like you need to talk with your attorney anymore about this? Have any questions or about this? You're absolutely clear this is what you want to do here today.
Absolutely, Your Honor.
And you feel like you've had all your legal questions answered that you want to have answered by your attorney?
Yes, sir.
And you do recognize that this will be a final resolution of the, at least other than the sentencing, a final resolution of your case?
Yes, sir.
Based upon that, the court will accept your plea. There'll be a plea to the bench. How long do you all anticipate needing?
Very brief from the defense perspective, Your Honor. Perhaps some testimony from the defendant, that's all.
Same from the state, just argument.
If a judge would be willing to hear it in the morning of August 22nd, seeing as you do have the morning of August 17th to buffer so many cases being set just a few days away.
Madam Clerk, your great minds think, well, I was thinking the exact same thing. So we'll do it August 22nd. We're gonna do it at 11 a.m. So we're gonna do it in the morning on the 22nd. Normally we do these in the afternoon. We'll do them in the morning because it's not gonna take too long. Okay? Thank you very much.
Thank you, Your Honor.
Taylor?
Ryan Morrow for Mr. Taylor, Your Honor. This is 19 CF 2910, 21 CF 250, and 22 CF 1746, and 22 CF 2182. Before we do anything else, Mr. Taylor had initially made a request for a Nelson hearing. He'd like to withdraw that request. We've spoken about that. If the court needs anything on the record, I'll defer to my client.
I'm gonna swear in just a second. Just raise your right hand. Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So I just want to make sure you're not making a request for a new attorney. You're satisfied with your attorney at this point in time?
Yes, sir.
Okay, you kind of had some discussion with him. Did you file a Nelson hearing? That's where you're asking to get your attorney removed. And you're withdrawing that. I just want to make sure you're clear about that.
Yes, Your Honor.
Okay, no one twist your arm.
No, sir.
Okay, based upon that, the court will accept your withdrawal of the Nelson request.
And moving the case forward, this is going to be a plea to the bench today, but the state was willing to make their offer of guidelines cap in the matter, and Mr. Taylor would like to accept that. I'll pause and allow him to sign it. Go ahead. Approach, Your Honor.
You may. What about fees and costs?
It'll be all the statutory fees and costs, Your Honor.
You need to put that in here as part of the plea agreement.
May I approach?
On the sentencing, when they're pleased to the bench, when we were having sentencing, we don't have to have the fees, but if it's a final adjudication, we've got to set forth the fees and make sure that he's aware.
This is a plea to the bench, Your Honor.
I thought you said there was a minimum.
Well, what I said was the state was willing to make their offer the cap, the guideline cap.
Oh, that's the cap.
Right.
Okay.
May I approach?
You may. I misunderstood that, and I was having a little hard time reading your writing, I'm sorry. What's the guideline?
27.9, Your Honor.
That's the minimum guideline?
That's correct, Your Honor.
The defense going to be arguing the reinstatement again?
Yes, Your Honor.
Departure.
Correct.
Mr. Taylor, did I swear you in?
Yes, sir.
I swore you in on
Yes,
this
Your
one,
Honor.
so you're still on the roll. So you, I see you signed the plea agreement. It contains the terms of the plea agreement that your attorney just stated, which is a plea to the bench. In other words, you're agreeing to a resolution of the case, but the sentencing is not yet determined. Do you understand how that works, how a plea to the bench works?
Yes, Your Honor.
In this case, the sentence is not determined, but there is a cap on it. There's a maximum that the court can order, but not a minimum. Is that your understanding? I want to make sure you understand this is a little different. This isn't a full-blown plea agreement because we don't have the actual sentencing part of the plea agreement determined.
Yes, Your Honor.
Okay? So it's indeterminate. Okay, you understand? You following me?
Yes, Your Honor.
Okay. So I want to make sure that, but there is a maximum cap of 27, 29 months DOC. Do you understand that?
Yes, Your Honor.
Is that what you've agreed to?
Yes, Your Honor.
Okay. But it could go below that.
Yes,
And the
Your Honor.
minimum guidelines are 27.9 months.
Yes, Your Honor.
Okay.
Your Honor, may
Yeah.
I?
Are you asking a question?
What I can say, Your Honor, is Mr. Taylor's asserted his desire to be sentenced sooner rather than later. His significant other is hospitalized at this current time, and I believe that's what he wants to raise.
Yes, we sent emails to your secretary, to Mr. Noah's secretary, also to Mr. Morrow concerning my significant other. She's in the hospital with a tumor in her intestines. And I know that some of the court dates have been pushed back to August 17th, and I'm hoping and that I could get this resolved sooner than August 17th. I'm here on a technical violation for a positive drug test. I've been in jail for 85 days. Hoping that I could receive some sanctions, some community service, ankle monitor. I've been on it before.
So what is the anticipated evidence or testimony that we're receiving?
They will not long, Your Honor. It would just take some testimony from my client from the defense perspective.
What's about the state? Who's the state calling?
The state would be calling the probation officer, Judge. He violated with a positive UA.
Your Honor, I'm guilty of the violation. I'm guilty of the violation, and I'm here to accept my punishment. And I also just want the court to know, as I have stated to Mr. Noah and to the court, I was overwhelmed with my family issues.
Don't argue that yet.
Yes,
That'll be
yes,
something
sir.
safe
Yes,
for
sir.
your,
Yes,
for your
sir.
sentence. Do you need testimony if he acknowledges that which he appears to be doing, he actually did acknowledge it, it's under oath, but not holding him to him right now.
Right. Well, of course, Judge, I do think I would need testimony from the probation officer, and the reason is because I have no idea what he's going to say, and the probation officer can provide background as to the truthfulness of some of his statements. So I definitely don't want to, roll in with no testimony.
We don't have any time.
I understand, Your Honor. It's a difficult situation.
I mean, I don't know, we've got a bunch of other cases. Mr. Medina's cases are still up. Okay. We don't even have any time. Completely booked up. What I'm thinking about doing, seeing if I can find another half day to do some of these hearings, but we've got to get them scheduled today. I do have some time the week of July 31st during that week, but when I try to add an additional day, I generally run into the attorneys telling me they're all booked up and they can't do them that day. And so I don't know whether I can do that. So I don't know what to say. I don't have any control of it. So, like I say, I don't even have anything in August. It's going to be September 12th. Would the state and Mr. Morrow
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hi, I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Bad Boy's Juicy Beef and Tasty Bird is located at 482 North Wilston Street in historic downtown Crestview, just 1 block from the courthouse. We open at 10 a.m. with amazing lunch specials until 2 p.m., serving incredible burgers, wings, sandwiches, and appetizers. Join us for happy hour Monday through Friday from 3 p.m. to 6 p.m. Hope to see you soon.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you
CF 335 and 22 CF 345. We have a violation of probation plea agreement worked out, and if I may approach with the agreement and the score sheet, Your Honor, signed by all parties. Thank you. Your Honor, under the agreement that has been reached, just wanted to state before I recite the terms of the agreement that Mr. Bolden had an offer that was ordinarily sounded really good. To basically, the state was going to allow him to reinstate to original terms and conditions his probation and just have VOP fees and public defender fees. But Mr. Bolden asked if I could get him a 6-month revoke and terminate deal because he thinks that's in his best interest. The state is okay with that, but I'm just putting on the record that that's a client decision on what he thinks is in his best interest. It's not necessarily with my recommendation one way or the other. Under this agreement, the defendant is admitting the VOP. He's been previously adjudicated guilty. It will be revoke and terminate the supervision, $100 VOP fee in each of the 2 cases, so 100 times 2, total of 250 public defender fees, 6 months Okaloosa County Jail. That's concurrent between all of the cases and counts with credit for all time served. And Your Honor, the state has also agreed, Mr. Bolden represents that he had approximately 7 days when he got picked up on the VOP for Okaloosa County before he got transferred over and arrested on the VOP here. So he is booked on the VOP. So the state has agreed to give him credit for whatever time he was held in Walton County on the VOP.
Does that need to be made clear in the agreement?
I can write it on there, Your Honor.
I just want to make sure you guys have agreed to it.
Yes.
He gets credit for it. It's not clear.
Yes, Judge. We had, I apologize.
That's all right. No, I just want to make sure that 2 things when we're doing a plea deal, we want to make sure, one, that you understand that everybody's clear about what you're agreeing to. That it's free and voluntary. We're not trying to trick you, we're going to kind of bait and switch where, we say we'll give you the 7 days and then don't make the writing clear and you don't get it.
And Your Honor, I am not the person who counts days, but it does appear that he was booked in Walton County Jail on 6/23/2023. and then released from Walton County Jail and returned to Okaloosa County on 6/29/2023.
Okay. Is the defense okay with the score sheet?
Yes, Your Honor, and it would be, I added with an asterisk, including Walton County jail time held on these VOPs only.
And I put all prior credit and critical time served after arrest for VOP in Walton County. Is that okay?
I think that's fine. The only thing is I haven't independently researched whether he was held on anything else there. I accept his representation, so I wrote it where it's held on these VOPs only, just in case he had something else that was holding him there. I'm not saying my client's not telling the truth, but I'm just trying to be very...
not be aware of exactly
right.
what's going on.
Right.
Okay. So, Mr. Bull, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Okay, so you heard your attorney state the terms of the plea agreement.
Yes, sir.
You can put your hand up. And I see you signed the written plea agreement.
Yes, sir.
Two questions. One, did you read the plea agreement closely?
Yes.
And did you go over it in detail with your attorney, make sure you had all your legal questions answered?
Yes.
And by doing this, you're waiving the right to go to a trial and force the state to prove their case. You believe this is in your best interest?
Absolutely.
Even the 6 months, which your attorney kind of explained that it was your choice?
That's my idea, yes, sir.
You believe that's in your best interest to do it this way? And I
Yes, sir.
understand, there's different ways to look at it, so that's your call.
Yes.
Okay. So, very good. Based upon that testimony, the court will accept your plea. And you've been previously adjudicated, the court will revoke and terminate, so you won't be on any more probation. You'll get the fees that are in the plea agreement, 6 months in the county jail on each of the charges concurrently, and you'll get credit for all time served, including the Walton County jail time held on the VOPs.
Your Honor, there were a couple of administrative questions. May I just have 1 second with him?
Sure.
Your Honor, this resolution does not in any way affect his driver's license suspension that he represents he had. Whatever driver's license suspension, that's between him and DMV, and this revoke and terminate doesn't get rid of any suspension that is in place, is my understanding. There's no commitment by this court order to restore his license or anything like that. That's what he's asking.
I'm going to make a statement that I don't know how I'm answering your question, but anything that's not contained in the plea agreement can count.
Okay, sounds good.
I don't hear that in the plea agreement, so that's not a part of it. I don't know. I'm not saying it could or could. I don't know.
Your Honor, probation raised a very good question, which, because we changed this to revoke and terminate, I probably need the paperwork back, because he would ask for, I would ask on his behalf for some time to pay the monetary obligations before they go to collections.
Sure.
Would this court permit 12 months to pay before the monetary
Say
obligations?
okay with that?
Yes, Your Honor.
Okay, thank you. So I'm adding that to the asterisk. You understand you'll have additional time. It won't impose any obligations on you. It'll just help you with your driver's license potentially, that the monetary obligations won't go to collections until 12 months after your release. So I just added the words 12 months to pay monetary obligations upon release.
Very good.
Thank you.
Okay. So, any questions, Mr. Cole?
What's those fees? Like, what are
the fees? The fees are $100
basically the cost of prosecution, it's called the VOP fee, times 2 for each of the VOPs, each of the 2 charges.
But Your Honor, the court doesn't keep an accounting of how much you already owe in prior cases. You know, that's up to the clerk of court, whatever, in probation, whatever your outstanding costs are.
These are the new fees that are a part of this plea agreement.
Okay, so I should just call the clerks.
They'll give you all the update on what's been paid, et cetera. But on this one, you get 100 times 2, that's 200 plus 250 for public defender, legal defense fees.
Sounds good.
Woefully undercompensated public defender.
Thank you.
Do you agree, Mr. Medina?
I've got no complaints. I am blessed, Your Honor. Thank you.
Okay. Thank you very much. Good luck.
Yeah, I'm giving you this. Just so you have a little copy. Scribble it on there. Thank you, Your Honor. Thank you.
Anthony Brown will be next. Anthony Brown.
Your Honor, Anthony Woods Brown is before the court in 23 CF 552 and 232333. I'm giving him a copy of the competency evaluation of Dr. Zeman that found that he was not competent to proceed. We're here today on a commitment order that is a standard commitment to DCF. And I don't think that there is any question that the state is not disagreeing with the Dr. Zeman's report, finding that he is not competent to proceed at this time. Yes.
Your Honor, the state has read Dr. Zeman's report and does stipulate to the report and its finding, and would agree that Mr. Brown should be found incompetent to proceed, and the court should order him sent to Florida State Hospital. I don't know if the court had the benefit of that report. I just don't recall off the top of my head.
It was court ordered.
Right, no, I remember.
And Your Honor, this was, so I'm approaching, if I may, again, with a stipulated order, a judging defendant incompetent to proceed and commitment to the DCF.
The court agrees and state order.
And hopefully we'll get Mr. Brown back restored relatively soon.
Good luck, Mr. Brown.
Thank you, Your Honor.
Bowman.
I do not have on my list of cases Mr. Bowman. I don't know if he's unrepresented.
I'm missing that page.
I do have Mr. Medina appointed to at least one of Mr. Bowman's new cases. He has a violation in 21 CF 2718.
Excuse me, were we missing a page?
No, sir. What it is Mr. Bowman is also on the plea day docket for this afternoon. He also has a new charge out of the state that has not got information in it yet because it's set out in August.
Your Honor, could we pass Mr. Bowman this afternoon? Now I realize which person this is. This is my afternoon Bowman.
What I found yesterday when I was preparing.
Okay. So I'm prepared for Mr. Bowman, but I need to go talk to him about this afternoon. So he needs to be coming back at the 1:30 docket anyway. And I'll talk to him. I'm sorry, I just didn't know which person this was. Okay. Thank you.
Okay, so we'll deal with, just remember to remind the court that we'll deal with the VOP.
Yes, Your Honor. I'm sorry, I had a cheat sheet and he was only on the afternoon part of my cheat sheet.
I didn't even.
Thank you.
Deontay Bradley.
Would you announce?
Yes, Your Honor. Steve Medina with Deontay. How do you pronounce your first name? Deontay. How do you pronounce your middle name? Nike Bradby in 18 CF 1025, 18 CF 1646, and the open felony case 21 CF 2615. Your Honor, he was hoping he could work these cases out to be released today. We have not reached a resolution with the state. We have filed in discussion with Ms. Sharpless. She has been allowed to review the not guilty by reason of insanity evaluation report of Dr. Randy McDonald. The state is not prepared to stipulate to a defense. Mr. Bradby has given me authority to go ahead and file that notice of the NGI defense. I have done that while I was in court this morning, and I am anticipating that the state is going to retain its own expert to get a second evaluation. I hope it will be done expeditiously. Mr. Bradby certainly hopes that, because he's been detained with a combination of Okaloosa County Jail and Florida State Hospital. I think it's around 2 years now. So if we could keep him set on August 16th, I hope that will be expedited.
And Your Honor, I already have a name of another doctor who does court-appointed NGI evaluations, and I intend to submit that order to the court.
Very good.
Hopefully.
So we'll come back on August 16th for pre-trial, not in.
Thank you, Your Honor.
Good luck.
William Branch.
She's not going to put on the minute she second evaluation needed, or just legal.
But it says
That's the
second
state
evaluation has been ordered. Right, the state has already ordered it. Thank you, that'd be good to put on.
Your Honor, may I proceed? This is William Marcus Branch. Mr. Branch's docket number 17, 22 CF 2390, 22 CF 2397, 22 CF 2412. I believe we have an agreement worked out. It's a DOC agreement. The state has to have additional alleged victim conversations, which it's hoping to be able to do over the lunch hour rather than keeping him until August 16. Can we just have him come back at 1:30 today, and we'll see if we can work him out this afternoon?
Yes. Come back at 1:30.
It's a substantial DOC agreement that I understand the state needs to make sure that this does its contract. Thank you.
Also needs to come back at 1:30. Duggar?
Your Honor, Mr. Duggar might have been an add-on. I'm not sure if he has a number on the docket. Shane Michael Duggar. Thank you, Your Honor. We're here on a motion for bond reduction, Your Honor. If I just might proceed on that. Just by way of background, the state's offer is 11 months, 29 days jail. As I set forth in the motion for bond reduction, he's seeking a signature bond. He currently has a $10,000 cash or professional. I think the most important thing to note, and he knows not to discuss the facts of the case, but there is my understanding, if he gets released on a signature bond, my understanding is he has to report for 2 years probation in Franklin County, so it's not like there's not going to be supervision in place if he were to get out on bond. Apparently, if we assume charges to be true for purposes of this motion for bond reduction, Mr. Duggar got apparently in similar type problems in more than one place, and he's obviously needing to address and resolve those similar type cases, and one of them has been resolved already in Franklin County. So just so the court knows, he beyond the Franklin County probation that he represents is in place. He also states that he is from Leon County and has a job waiting for him there. I would like for Mr. Duggar to be able to confirm what I've represented to the court as to whether it's factual or not, if the court will permit him to be sworn.
So would you please raise your right hand? Do you swear or affirm the information about to provide this court is the truth, nothing but the truth, so help you God?
Yes, Your Honor.
Without talking about your facts or making any admissions, is it true that you are currently under a Franklin County sentence that requires you to do 2 years probation commencing upon release?
Yes, as soon as I get released, I have to check in.
In Franklin County, do you know what the county seat over there is for that? Where were you going to be checking in?
And Leon.
Oh, you're going to be checking on Leon?
They allowed me to transfer to Leon so I can keep my job and not have to worry about traveling back and forth.
And where is your job in Leon?
I am a brick mason. Work for a landscaping company, Dickerson Landscaping. I've been there 3.5 years. We've got 5 children, so.
Okay. All right, thank you. Nothing further, Your Honor.
And so what is the defense requesting?
I'm requesting the signature bond and the 10,000 cash for professional be changed to signature, Your Honor.
Yes, Your Honor. So the issue that the state has with this case is that in the interim of this case happening, apparently there were some issues in Franklin County, and that's why the offense from our case is from earlier this year. It has taken several months for us to get him back from Franklin County. So I know he's on probation, but the state is worried about his ability to stay out of trouble. And the 1129 offer is what it is. I do feel that is going to be appropriate. The victim in this case was unable to be here today, Your Honor, but that she is 65 years old, so she is living on a fixed income, and this did place some financial burden on her against the fraud. So the state would request that the bond remain as it's set.
So can you give me the timeline for the cases when they occurred?
So, Your Honor, this was reported to the Okaloosa County Sheriff's Office in February of 2023. Investigator Walters did some investigating. He got some video confirming what was told to him by witnesses in March. He was able to get some subpoenas and get some information back from the bank confirming the transactions, again confirming what the witnesses told him. He submitted a warrant application in April, and then it was discovered that Mr. Duggar was in Franklin County Jail.
And what about the timeline of the Franklin County case?
Your Honor, may I ask him?
Sure, anybody can.
Unless the state wants to.
I don't have that information offhand. I can look it up really quickly and see.
Do you have any outstanding case in Franklin County? Is your Franklin County case resolved?
It's resolved.
When did you plea it out approximately?
May 9th.
May 9th, okay.
Yep. And they had me on a hold from May 9th to June 9th when they transferred me to here.
In the Franklin County incident, what date was that incident or incidents? Do you know a date or date range when you're saying you did something wrong over there?
It was February 8th, I do believe.
Okay, this year?
Yes, this year.
All right, thank you. Well, this particular case in Okaloosa County apparently alleges things on February 8th, but it is approximately the same, similar time frame?
Yes, sir.
This year for sure?
Yes.
Okay, thank you.
And just so you know, I do think that is an accurate timeline. It does look like he had a active warrant in Franklin County starting on, it says February the 7th, but it looks like that warrant was served on March the 10th. And then that a plea was entered on May 9th.
Your Honor, the state is, I think, indicating it might be able to have additional victim contact, but I don't think we have a resolution today about whether there could be something. So we don't have anything further to add. It's just with the 5 children, he will be under careful state probation control. And we ask for the court's consideration of the arguments that we've made. Thank you.
The court will reduce the bond. I'm not going to reduce it to a signature bond, but I'm going to reduce it to a $3,500 capture professional bond.
Thank you, Your Honor. And if he could remain on August 16 docket.
Very good. August 16th at 9 a.m.
Okay. Thank you, Your Honor.
One of them is dated yesterday, that's page 10, the other one is dated July 13th.
Thank you. Thanks for that.
It's the one, yes.
Better look good. You look good, man.
Ms. Medina, is that the last of your cases?
Barring something I've missed, I think so, Your Honor, yes.
Okay, so that will be a wrap for this morning. We will reconvene at, you're through on this morning. You don't have any more this morning, do you?
We just had Mr. Frazier, I'm going to give him a call.
I'm going to give him a call. So there's a couple other ones that we were going to